Hello, I'm Ken Swinton and I'm a council member of the Scottish Law Agents Society. We've decided to provide some free online CPD given the current situation, and this is one of those offerings. So what I'm going to speak about today is searching and the personal register. I thought it would be an appropriate time to review this area given the recent decision in Commodity Solutions. So I'm going to look at this in 4 sections, and those 4 sections will be 4 separate video clips. The first of those relates to inhibitions themselves. The second will deal with searching. The third will deal with liability of searchers. And the 4th section, which is related but slightly different, deals with land adjudication, the system of diligence that we don't have in force in Scotland at the moment. And that was a special request from our Vice President, David McLennan. So, this section is going to deal with inhibitions. What I thought we should do is start off looking at the effects of an inhibition, and where a creditor obtains an inhibition against a debtor, as we all know, it prevents certain standard juridical acts of the debtor in relation to heritable property standing in the name of the debtor. And those standard juridical acts are sale, gift, lease or security being granted over the inhibited subjects. An inhibition, however, ceases to have effect on the death of the debtor. An inhibition doesn't give the creditor the right to sell property, nor does it give the creditor a right to possess the property. And in that restriction on the nature of an inhibition, we can see that it is in fact a comparatively weak diligence. It operates simply as a warning to third parties who transact with the debtor that their title is subject to reduction. So, the principal thing to bear in mind about inhibition is that it is not directed against any specific heritable property. Rather, it is directed against the debtor, and it automatically affects all heritage owned by the debtor. It is a universal diligence, and in that sense the creditor may be conducting a fishing exercise, as the creditor may be quite unaware of what, if any, heritable property the debtor actually owns. Inhibition is not a prerequisite to further diligence of adjudication by which title can be transferred to the creditor, normally after the expiry of a 10-year period. But often it is used pending adjudication, or in the very few cases where adjudication is resorted to. Adjudication for debt was prospectively abolished by the Bankruptcy and Diligence Act 2007, but when the SNP administration was formed in 2007, they determined that they would not bring these provisions of the previous Labour Scottish Government into effect. The result of that, as we'll see later, is that there is no truly effective diligence against land by which a creditor can transfer title or have that land sold. The next question that we've got to address is, when is an inhibition effective? At common law, and common law hasn't been applicable for a very long time, it was effective immediately. It remained effective if registered within 40 days. The language used in the execution of an inhibition suggests that it's effective immediately, but it isn't. The Titles to Land Consolidation Act 1868 continues to rule in relation to inhibitions. So it's quite an old piece of legislation, although it was significantly amended by provisions in the Bankruptcy and Diligence Act 2007, which did come into force. So section 155 of the 1868 Act, which is a replacement section brought in by section 149 of the 2007 Act, provides that the effective date is the date of registration, and there is therefore a window of opportunity in which the debtor might seek to transact with the property before that registration is effected. The 1868 Act had what was perhaps one of the first systems of priority notices in Scots law, and it provided for a notice of inhibition to be registered against a property, and that is contained, or at least the style to be used in a notice of inhibition, is provided for in section Schedule PP of the 1868 Act. It is, or it renders a subsequent inhibition effective, provided that inhibition itself is registered, so that's served and registered in the register within 21 days of the registration of that notice. And if no inhibition follows within that period, then the notice of inhibition simply falls away. That notice of inhibition can be obtained without reference to the debtor, and it effectively prevents the debtor from dealing in that 21-day period. Inhibition was often granted in the past on the dependence of a court action in the Court of Session, or by the granting of letters of inhibition in the Court of Session, dependent on an action which had already been served in a sheriff court action. Letters of inhibition, however, were subject to significant restriction by the decision in Carroll Construction against Palisade Properties in 2002. So it's nearly 2 decades old now, but this was one of the first challenges in the Scottish courts, based in part at least on human rights considerations, and in particular A1P1 considerations. So Article 1 of Protocol 1 to the Convention deals with property rights, and an inhibition where the debtor has no opportunity to object to its creation, and it is granted on the dependence of a court action or on letters of inhibition, is a situation where the restrictions on the debtor's property, or his ability or her ability to deal with that property, amounts to an interference that is regarded as interfering with their legitimate interest in the property and fails the proportionality test. It was always thought that letters of inhibition would be one of the areas that were subject to challenge under the Human Rights Act, and in Carroll Construction it was found contrary to both common law and potentially, although the case wasn't actually decided on that basis, on A1P1 considerations. The provisions in the Act, in section 169, permit the granting of an inhibition now, this is under the Bankruptcy and Diligence Act, directly in court proceedings, whether they're raised in the Court of Session or in the Sheriff Court. So this was an innovation that was brought in 2007, it being felt by the Scottish Law Commission in their previous report that it was a lacuna in the legislation that prevented actions relating to property in the Sheriff Court dealing with, not necessarily actions relating to property, but any action in the Sheriff Court, preventing an inhibition being granted there rather than simply in the Court of Session. So the test for granting of the test for granting in an action in the Sheriff Court or the Court of Session after the combined effect of the 2007 Act and the terms of the Carl Properties decision is that there must be a prima facie valid case for the creditor. There must be a real and substantial risk that the creditor's rights would be defeated or prejudiced if the inhibition was not granted, and that the debtor is insolvent or vergens ad inopiam, verging on insolvency, or otherwise likely to deal with their assets. The court must fix a hearing. That hearing must be intimated to the debtor, and the same tests as I've set out already must be complied with, and the court must also determine that it's reasonable to grant the order craved, in other words satisfying the proportionality test, and the onus of course lies on the creditor to satisfy the court on all these aspects. When an order is granted, the creditor must serve the principal action within 21 days, and that leads to a failure of the inhibition if the creditor does not do so. So that represents the first section of this seminar, and it's brought to a close at this point.